Bhandari, on the behalf of Law at NUV, welcomes everyone, our esteemed faculties, the distinguished guests for the day, and all the participants present. Today, it is an honor for us to have Mr. Hasit Seth with us. Hasit Seth, sir, is a working counsel in the Bombay High Court and in
Yeah.
arbitrations. His work focus is on
Ashit
arbitrations,
sir, you can
civil,
join the session. You can
and writ
on the link.
litigation.
Yes, yes.
Okay.
Over the past 20 years, he has been a partner at an Indian law firm, general counsel for a
Which
MNC,
app
a startup founder,
is it?
and has worked in US with two law firms doing patent litigation and prosecution as an associate. His basic degree is in BSc in
Yes,
computer science.
Tarush.
Yes, ma'am. Hello. Ma'am, am I audible?
Yes, Tarush, you're audible. Please go ahead.
His basic degree is in BSc Computer Science, followed by LLB and LLM with a gold medal from Mumbai University. He later did an LLM in IP from Franklin Pierce Law Center at University of New Hampshire in US to pursue his interest in negotiations and mediations. He completed courses at the Harvard Law School campus. His interest areas include technology, economics, and art. Sir, it is an honor for us to have you with here. The stage is all yours, sir.
Thank you, Tarush. Am I audible?
Yes, sir, you are audible.
Okay, thank you. Thank you, Dr. Sujata Patil and everybody at the Navrachna University for this opportunity to address you on the topic of careers in arbitration and trial practice. And I particularly thank Dr. Patil for following up with me for months, to chase me and get me to speak on this. And I had thought about what topic to speak. There are lots of technical topics to sort of discuss within the trial practice and arbitration. Both are vast worlds. But I just thought, let me speak about careers in trial and arbitration practice as a one topic, because we have so many lawyers, advocates in small to large places who are doing both. They are doing trial and arbitration practice together. So the big thing behind it, why people are doing both the work together, is that the underlying mechanism is very similar. And the training and skills required for arbitration and training are broadly similar, although they are not exactly the same, but they are broadly similar. So I thought it would be nice to discuss both the things together in one talk. So that was the idea behind it. The organizers will tell you where you can put questions, I think in the chat box or somewhere. I'll try and cover them during the course of the talk or later on, or maybe you can raise a hand or whatever the mechanism is. All right, so the first thing, to understand is that it's a big decision to choose which career to take, because law is a generalist course. Unlike even, like commerce or management, where you now have undergraduate degrees, like Bachelor of Financial Management, Financial Applications, or Bachelor of International Trade, etc. Law remains stubbornly around the world as a generalist degree. And we still don't have anybody saying that I've done LLB in criminal law, or I've done LLB in, tort law, or some particular law. That's the saving grace, that our profession is designed to be a generalist profession, and our training for 3 years or 5 years in law school, we are supposed to be generalist lawyers. Just like the MBBS doctors, that's the closest analogy, where you are a generic doctor for everything, and then you go on to specialize into something. That's how the profession is. You're trained to be a generalist, like both a civil lawyer or criminal lawyer. I was reading a judge's interview. He's a sitting judge in a particular high court. He said during their conference with the Chief Justice monthly or whenever it may be, no judge really has a choice of which kind of matters will be assigned to them. It doesn't matter if they did civil practice or they did tax practice or they did labor practice in their practicing days. Whatever is the assignment given to them, they have to do well. So if you read, like Justice Chagla's autobiography, Roses in December, and I recommend it to everybody to read because the English is very beautiful in the book, apart from his wonderful life and achievements. One thing he says that he was assigned to sit in a tax bench, and he really had no tax background in practice, it seems, because he was Muhammad Ali Jinnah's junior, MA Jinnah's junior, and like he didn't have a tax practice. So he said, but he picked it on the go. And, like today, some of the, if you ask the old school practitioners, some of the best tax judgments are from his pen and dictation. I mean, Palkhiwala also mentions him as a great influence on his career, on his tax career, because Justice Chagla used to like his arguments, and there's so many tax judgments. So the point is that we are a generalist profession by training and design. So it becomes a big decision, because we are a generalist profession by training and design, to choose which kind of practice to do. And it's not unusual to go with the trend. It's very common. So there was a time when everybody did, like telecommunication engineering or electronics engineering or computer engineering. And that's the trend. I mean, if people think that there are lots of jobs in a certain area, and there happens to be a concentration of jobs due to multiple factors in certain areas at certain time. And that's what happened to us also. So for example, to tell you, when I passed out from law college in 1998, there were like a handful of firms in Bombay who were doing corporate law, and perhaps nothing in Delhi. Perhaps, I mean, I can't remember a firm in Delhi doing corporate transactional practice at that point of time. So all this happened primarily due to the liberalization that happened in 91, 92. And you had so many options open up, so many firms grew up to be transactional practice firms, and they had large transactional practice with a lot of partners. So at that point of time, somebody to make a choice to be a transaction lawyer or a litigation lawyer, I think a lot of people would have chosen to be a litigation lawyer, because that's where the opportunities were most of the time. So it's not unusual to do it. And these things kind of change over time. So just like if you look at the telecommunication field, and I've said that in one interview, that today the telecommunication field is limited to just 2 or 3 companies. I mean, but 10 years ago, there were tens of companies, and lots of jobs were there. There were specialists of telecommunication law also. Lots of partners, firms saying that we do telecommunication law practice, but all that has disappeared. And that's a function of a developing economy. Lots of jobs will be created in certain areas, and lots of jobs will be destroyed in certain areas. So these things will keep happening. So the idea is to choose some standard advice to give is to choose some broad generalist area of practice, and then, like over time, within somewhere between a block of 3 to 5 years, like develop certain expertise in certain areas. And certain things are very long term. For example, labor law. You don't have factories, like factories will always remain, and you will always have either industrial labor law or you'll have service-oriented labor law if the service sector of the economy grows up. So the labor law is not going away anywhere, because labor is going to be around. So it has a very long longevity of a lifespan. But within that, you will have sometimes matters taken to tribunal, you have sometimes matters taken to courts, and the jurisdictions will keep swapping on and off. So always choose, like a broad area of practice, and then choose, like 5 years career block to develop expertise in that particular span of time. Coming to like these 2 options, trial practice and arbitration practice, and because so many lawyers practice both of them at the same time, although there is a demand from a lot of arbitration practitioners that there should be a dedicated arbitration bar, in the sense that lawyers should only do arbitration work if they are going to be arbitration specialists. So that's all right. That's all right to expect, and that's happening in some cases. I know some people who are specialist arbitration lawyers, but it's not that they don't come to court. They do come to court on and off. I mean, and it's a choice that they have made, and that they are fine with living with it. So, and their professional careers are in that area, so that's okay. But given, like a choice to make early on for a young lawyer who is just out, about to graduate or has graduated, then I think, like the broad idea should be that you're going to be a dispute resolution lawyer. Now, within that, you can choose criminal law, but that's an entirely different area of practice, and that's not what I'm going to discuss at this point. But within civil law, civil and arbitration practice are a good choice to begin your career with. And if you have that clarity, and lots of people don't have that clarity, and it's okay not to have clarity and, try and do some other things and figure out what is your calling or what is your choice that you want to do in terms of practice. It's okay to take some time to decide it, maybe a couple of years, maybe 2-3 years. But more than 3 years, you are in the danger zone, because you will have lost some time if you switch over to something. And by the time other people in your age group might have collected more experience, and you might feel it's more psychological than anything else, that you might feel that you are a late entrant to that field. So it's okay to have a couple of years to figure out what's best for you. And that's why we now have so many internships and all those programs going on for people to essentially figure out what's their calling as such. But presuming that you have decided that dispute resolution in civil practice is what you plan to do, then there are certain choices to be made after you have made that broad choice. And then if you have made that choice early on in your first or second year of your 3-year course, or third or fourth year of your 5-year course, then you need to prepare yourself in that direction, because everything in life requires preparation. I don't know of anybody as a lawyer who is born with that talent that, like simply they came and, like just picked up a book and became like excellent lawyer. This is a field which is extremely demanding in terms of reading. It requires the sheer amount of text and information that needs to be digested. And it's always growing. So some people would, like, if I started, like say 20 years ago, the number of judgments were what is there today minus 20 years of, like case law and statutes. So it's always going to increase even by the time you practice, and it's going to be a lot. So if you go to study in US, or you know a bit about US law, they have over 200 years of case law, and not just federal case law, but state case law. And that actually is even older than that, because the states were there even before the federal government. So there is a sheer massive amount of material to digest. Obviously, nobody says you have to read everything. Nobody says that you need to read everything or digest everything. But what you need are methods to deal with so much of material. And that's what you can develop during your time in college, or right when you are junior and all that. So there is this big refrain everywhere, a complaint everywhere, that our dispute resolution has a lot of waiting time, in the sense that by the time you're successful or you make a lot of money, or, like necessary amount of money, there is a lot of waiting time. But try and understand that that's also the time this field requires you to absorb the amount of information out there. I don't think so there is any law college, and I have done some work, studied a bit at Harvard Law School and also done an LMUs. No law school claims that we'll be able to teach you everything that you will need in your career. It's just an impossibility. So there is a lot of talk about like industry, like practical knowledge being given in like making the law course very practical, even in US and in India. But it's just impossible task, to, like give you theoretical and practical knowledge at the same time within the span of 3 years or 5 years, it may be. So essentially what you need are tools, techniques, and methods to figure out how much you need to know, when you need to know, and how you are going to absorb that amount of information. So that's the preparation you can do after you have made the choice that you are going to be a dispute resolution lawyer. You are going to be a litigating lawyer as such. I mean, so the main choice in terms of practical terms is the choice to make about where you will practice. Because just like they say, all politics is local, even international politics is local politics, all practice of law is local, in the sense that wherever you live, essentially, that's your zone of practice. Even the most busiest lawyer have a home court, in the sense that that's where they started, or that's where most of their practice is. So if you take up any 4 or 5 top lawyers in India who are the most busy litigating lawyers, they always have a home court where if they are nowhere else around the country or internationally, they are always back to their home court and doing something, in terms of matters or meeting clients or something. So that's like, you will need a home base in litigation, because that's how you start off and grow, I mean. So that location is a big choice. And I am not one to say that the location always needs to be a very big city. So there are metropolitan cities, I mean, no doubt about it, that they have lots of commercial activities going on. Lots of governmental activities go on in the capital of a state or capital of a country. So naturally, there is more work. So Delhi has lots of national tribunals, like National Consumer Disputes Tribunal, and you have the CAT's main bench, and you have the appellate tribunal for armed forces, whatnot. I mean, it has all the apex tribunals in one place. And NCLAT is there, I mean, in Delhi. The only national level tribunal in Bombay that I know of is the Securities Appellate Tribunal. There is no Securities Appellate Tribunal in Delhi. So the metropolitan cities do offer you a wider range of choices in terms of the forums where you can practice. But it's not there that the other places don't have opportunities, because the whole story of economic liberalization and progress of India is linked with, like opportunities and wealth spreading to like smaller and smaller cities. Because otherwise, like you'll have so much of migration happening to larger cities, and the government itself doesn't want it. It wants tier 2, tier 3 cities to develop. So to give you examples, like Surat, for example, in Gujarat, or Indore in Madhya Pradesh, or even Pune in Maharashtra, these are also very thriving industrial centers. They are also very thriving commercial centers. So lots of companies are based there and lots of work is available there. So it's okay to make a choice to be in a tier 2 city also. And even in the smallest taluka place where the courts exist, litigating lawyers have work. I mean, how much it pays and, how much you can grow in it, and whether the work is intellectually challenging. I know the factors differ. There is a wide range of these factors, I mean, but if you take litigation practice to be one client, one case, one judge, one court a day, I mean, then I think the litigation practice is pretty much same, not just across the country, but across the world. I mean, so for a litigating lawyer, it's always a new day, a new client, or maybe old client's new matter, and one courtroom and one argument to make and one thing to study. So at a time, I'm saying. So if your approach is that, then it really doesn't matter where you start off and where opportunities open up for you during the course of your career, or during, this thing, because you have lots of lawyers who start in trial courts and move to high courts. You have lots of lawyers who move from high courts to Supreme Court to practice after a few years. And there are lots of also lawyers who move from trial court to, high court and then Supreme Court, and maybe even have international practice at some point. Or while they are at high court, they might have international practice. So it's all right to have these different career paths, but it's always the same thing: one client, one matter, one court a day. You're always doing that on any given day. So your work will not differ. If the forums may differ, or, like the money may differ, or the kind of matters may differ, but The preparation and the method will be remain the same. You have to read up the law, you have to read up the facts, you have to talk to the clients, you have to achieve what your clients' goal are in a very fair and honest manner, because under the Advocates Act 1961, we are all officers of the court. I mean, we are supposed to, like our first duty is towards the court, not towards our client. I mean, we have to be fair to the court. I mean, so any given day, you will be asked to do that. I mean, in any court, anywhere across India. So, but let me tell you, like not give you just a very general, broad overview of things as such, but also give you some practical situation that what is the situation across trial courts in India. And there is, whatever I say, take it with, like not just a pinch of salt, but a sack of salt, because local factors vary dramatically. There are districts which are economically extremely rich, and there are districts which are very economically lacking in many things, in resources, in terms of work, in terms of agriculture, many different things, industrial activities, etc. So your work will also vary as a civil lawyer across the districts. But this is what I'm going to say is a common pattern with a wide margin of error across, different geographical areas. Consider it an average, which you'll have to adjust in whatever circumstances you are. But the kind of practices exist across district courts in India and also like the high courts in India. Let's take first the case of district courts. The kind of trial practice that's there in the district courts, it covers, according to me, there are 8 major areas of the district court practice. The first practice is land acquisition. The government is pumping billions of dollars, thousands of crores into building roads across India, highways, and expanding those. Wherever there are highways, they're making 4-lane, 6-lane, 8-lane, etc. So you have bullet trains coming, and like all kinds of infrastructure is coming. All that involves land acquisition. Since the 2000 Act, which is that Right to Fair Compensation Act, which replaced the old Land Acquisition Act, land acquisition still is extremely challenging across India. And because it involves the revenue authorities who are in charge of the land, who do the measurement of the land, the valuation of the land, and then the NHAI, National Highway Authority, notifies it, and for industrial areas also government keeps acquiring land. For different things governments acquire land, which sometimes is called eminent domain powers and all that. So land acquisition has a lot of legal component. It also has an arbitration component. Under the NHAI Act, there is an arbitration. And the interesting part is kind of an arbitration because the award of the arbitration, the arbitrator there is challengeable under the Arbitration and Conciliation Act, but the appointment of the arbitrator is through a different act. So there are a number of this act, even number of labor law acts are there, where they use the primary mechanism which they use is their own arbitration mechanism under their own act, but the review of the award is given to the regular courts, I mean, under Section 34, that you review the award. So that's what the government has found out as via media to essentially not have everything land up in writ petitions. Because otherwise writ petitions is such a general remedy that almost anything and everything against the government, you can file a writ petition against it, unless the standard argument of an alternative efficacious remedy is available. And they have found out this arbitration to be there. So land acquisition remains a major activity. And because the government spends so much and because the clients actually make money out of, escalations of the estimation which is done by the government that how much you should be compensated for land acquisition. So that remains a major area of practice, I mean, in district courts. Then the second big category is actually tort law, which most people think that it's a dead law in India, but it's the codified tort law, which is a major field of practice in district courts, and that is under the Motor Vehicles Act. So under the Motor Vehicles Act, wherever accidents happen and people get injured or people die, obviously this is the tort of negligence in some way, or strict liability to some extent. I mean, in certain cases, like you're carrying a petrol tanker, you know that, like the petrol is inflammable. Let's say that if there is an accident and it spills and petrol catches fire, obviously there's a strict liability questions, like Ryland versus Fletcher. You're dealing with wild animals and the wild animal runs away, your strict liability is there for it, irrespective of whether you can prove the damage or not. I mean, so in the same way, it's about those petrol tankers and all that kind of stuff. I mean, there is strict liability element in the Motor Vehicles Act also, and also the regular remedy of negligence. It also falls under rash and negligent driving, etc., under the criminal statutes, but that's a different aspect altogether. Motor Vehicle Act also has criminal offenses, but primarily the responsibility under the Motor Vehicles Act is to compensate people for accidents. And accidents happen everywhere. It is a very sad statistic to share that India has the world's largest number of accidents on the roads across the world. So this is actually the tort capital of the world in that sense. I mean, so the lawyers in US who do personal injury litigation, it's known as PI litigation. They are known as ambulance chasers. That as soon as an ambulance comes, I mean, to take away somebody, they chase that ambulance to get legal work. I mean, so they have a notorious reputation for it. But that's also a lot of work. India also has the world's largest number of fatalities in accidents. Largest number of people die in accidents. Now, way the scheme under the Motor Vehicles Act is that it's a very liberal law. So it's actually a tribunal. It's not not a court. So within the court premises, within the district court premises, you actually have a tribunal. So that is MACT, Motor Accidents Claim Tribunal. And there is an appellate tribunal, at a regional level and all that as such. And then you have writ petitions against it. The Motor Vehicles, Act related claims also, you can put a parallel claim under workmen's compensation, now called the Employment Compensation Act. You can also have a consumer complaint because the insurance company didn't pay up. So these 3-4 jurisdictions work in parallel at the time. You cannot do double recovery. If you recover under the one act, it is reduced under the other act. But it's a fascinating law which requires some bit of medical knowledge to determine the degree of disability. You have to cross-examine doctors in it. You need to know a lot about the roads and vehicles and all that for all that accidents. And you need to know insurance law, the general insurance law as such. And you need to know the Motor Vehicle Act, lots of work exists because lots of accidents happen and it has a no-fault liability. Last I checked, it was 50,000. So irrespective of whose fault it was in accident, the insurance company has to pay 50,000 for the death of a person. So lots of legal work, and it's a work very suitable to a beginner because it's a tribunal. It's a very forgiving tribunal in that sense. The evidence law is there and all that. That's fine. But lots of being a tribunal, there are lots of relaxations to it. And it's a form-driven tribunal. There's a AA form in the Motor Vehicles Act by which you file claims and all that. So it's an easy thing for a beginner to start because it tolerates some mistakes. So if you are in a district place, consider, and you're a civil dispute lawyer, these are two good areas of practice to begin with as such. And like different branches of law, malpractices have crept up in all these fields. Particularly land acquisition and motor vehicles like MSCT tribunals. But there is ample room to do honest practice, and there is ample room to apply talent. This thing, because I'll give you a statistic. I write a lot of summaries of Supreme Court and other court cases on LinkedIn and all that. My thumb rule is 10% of Supreme Court's judgment reported every year are under the Motor Vehicles Act. So it's a large component of even Supreme Court's docket. Because not every litigant goes till Supreme Court to recover compensation. Not insurance companies do. In the Lok Adalats, the motor vehicle related Lok Adalats have some of the highest disposals of cases. That the sheer number of cases filed is enormous. This thing. So these are two large areas of practice out of the 8 that I want to mention. The third component of these practices in district court is the family law practice. or whatever you want to say, but it's a very growing area of practice. Socially, a lot of people say that it's not the best thing that the family law practice should grow, because it indicates that there is lots of social discord, I mean, but it's a very individual law. If some people don't want to live together, what will law do? I mean, that will only help to separate them amicably and take care of the children and all these things which the family law does. And it's an interesting amalgam of personal law and statutory law. So the personal is always there in the family law, and the statutory law is always there. So it's a very big growing area of practice across states. Different family courts, dedicated family courts are being set up. And this is also a law where evidence law it takes a backseat. The strict evidence law takes a backseat, and also a good thing for a beginner. And you can have a lot of satisfaction in either solving, people's problems, or getting, them to assert their rights. So large area of practice, and can be practiced from the smallest court to the highest court, I mean, as possible. In any country, in fact, not just India. The district courts have very little of commercial practice, which means intellectual property, arbitrations, commercial contracts, related work, but there is a little bit of it. What is the reason why people are not coming to the civil courts in smaller places to solve them is the sheer amount of time taken in the appeals. Actually, district courts decide trials very fast. District courts don't have a problem of like lots of lack of resources or courts or judiciary. It's a very misnomer and a wrong impression that the district courts are slow. Our bottlenecks in the delays, etc., are the high courts, because there are so many appeals given to the high court. Article 227 requires all the appeals, like where no appeal is there under Order 43 Rule 1A to be taken to the high court under 227 and all that. All that has created massive backlogs. I mean, but otherwise, trial courts are quite fast, and we have good judges in trial courts. If we practice in trial courts, we'll see very little complaint about the competence of trial court judges to do the routine work, because they handle evidence law day in and day out. They handle witnesses day in and day out. So for them, this is not a problem, and they know civil and criminal law both at the same time. So they really know their stuff very well. And a good trial court practitioner should not need more than a couple of years to dispose of any trial. I mean, if you are diligent enough, I think you can get a trial decision in 2 years, minus any time taken by the high courts or the superior courts, I mean, anywhere as such. So there is scope to do that also in smaller places. Although appointment in arbitrations under Section 11 of arbitrators are done by the high courts. So, but if the contract says that the seat of the arbitration is a particular district and a particular location, then nobody is going to object to it because that's the party autonomy principle. But the appointments of the arbitrator are done through the high courts. But the interim relief, if a seat is a particular district, Section 9 powers can be exercised by the district courts. So that work is, and the challenge to the award, if the seat is a particular court, courts at a particular seat, then the Section 34 challenge also lies to the district court. So there is scope for practice, and this is only going to grow over time. It's not going to reduce. There is one more area which I include under this broad heading of commercial law practice in district courts is the consumer courts. So after the 2019 amendments, the consumer courts actually they were supposed to get 2 crores of jurisdiction, pecuniary jurisdiction, but now it's come to 50 lakhs, I mean. So they do have a lot of scope for litigation there. And the big category there is a surprise. If you go to any district place, the biggest growth is the reason what is there in the news, Ukraine and all that, are the doctors. So you have lots of people wanting to become doctors, and after becoming doctors, they set up hospitals. And where are they setting up? They are not setting up it in like large cities. They are setting up it in small centers, because large cities already have a lot of hospitals. So they are setting up it in smaller and smaller towns. So district places, taluka places, they are setting up hospitals. Now, after they set up hospitals, and there is bound to be medical negligence there. It's just the way things are. And hence, like there is a lot of potential to do consumer litigation in the district forums because of like so much, let's say, the money the doctors are making from the patients. I mean, there will be unhappy patients, and there will be patients who really need, like remedies against the doctor, and vice versa. There will doctors who will need legal representation to defend themselves, and you will need a lot of knowledge of the medical field to be able to defend them. And again, the consumer courts are an easy thing for the beginner to start with, for the simple reason that there is rare oral evidence or no provision for oral evidence technically. I mean, so all that happens on affidavit evidence, and you could do it very well, without having a very long training in oral evidence procedures. I mean, so it's like just like a tribunal of some kind. So that then there are charity commissioners at regional level. There are cooperative commissioners at regional level. All have quasi-judicial powers. Lots of like hearings happen there, and management bodies and elections are challenged, and all that work keeps happening in district courts. So avenues are there to do that also. The next category is one category which is actually reducing is rent litigation. So rent litigation, what my late dad used to say, was a trial lawyer, is that rent litigation was the training ground for civil lawyers, because the grounds were limited under the rent acts, the state rent acts, I mean, under which you could get eviction of a tenant, or the tenant could protect their tenancies. I mean, usually bona fide need and all that, I mean, or breach of tenancies like regulations and all that. So you could actually start off, learning civil law and marshalling the facts, because rent litigation is all about facts. I mean, the tenant broke a wall, the landlord stopped water supply and this and that. I mean, the tenant put up an AC without landlord's permission and all that. So that part of it is now under leave-in license, after the Model Tenancy Act in 2000, it's under leave-in license, and there is a rent controller in most states. It's gone to that administrative side on that leave-in license side. But a lot of rent litigation still exists, but it's not increasing because the property prices have gone up and people have rebuilt places and have actually given tenants new flats and all that. And in some states, places like Bombay, the government actually gives you increased FSI to build more and give tenants, like new places. There is municipal law, there is municipal corporation law, lots of rules, breaches, old buildings, dilapidated buildings, like in Bombay, Section 354 of Bombay Municipal Corporation. Similarly, in all metropolitan areas, there's litigation around it. Then there's a category which is the mother of all disputes. I mean, there are two categories which are the mother of all dispute litigations. I mean, one is property litigation, and property litigation related to family. So you had somebody who didn't make a will. You had interstate succession. How should the succession be done? There was a joint family ancestral property. Partition has not happened. You have class 1 heirs. I mean, how property should be distributed to them. You have predeceased daughters and predeceased, like sons and children of that, and second wives and this and that. I mean, so property litigation is the most complex litigation that exists, with mortgages, leases, everything under the Transfer of Property Act. I mean, as such, gifts, I mean, whatever you want to call it. It's a very complicated branch of law, and mostly some training under a senior is required before you start property litigation. I mean, but that remains as a class of litigation, because there is no yet, like solution found to the Hindu Succession Act, Indian Succession Act, or, like all the personal laws under which, there are different per stripage distribution and all that. So that litigation has no end, I mean. And nobody's, like bringing a unified statute for that in any hurry. I don't see that happening in the next 50 years at least. I mean, so that litigation remains as a category. The next, are the payment disputes. So there is a core problem in Indian law and Indian society that excess paid money to Y is not paying back. So what do? So you have all these remedies which have been invented to solve the same problem, that why is Y not paying up. So you have the basic remedy of civil suit. Now you wanted more faster remedies. So there is summary suit under, say, Order 37. Then you wanted a more faster remedy. So you brought in arbitration, where you even removed the courts out of the picture, that you can have private this thing. Now you wanted for companies, there was winding up. That you could wind up because they were unable to pay debts. Then there was remedy which was brought, which is recovery of debt due to banks, and DRT and SURFACE laws were brought up. Then you have more remedies under a different act, in Consumer Act, if you paid money, deposit with the bank and it's not paying you and all that. But the core problem of Indian law remains that excess paid money to Y and Y is not paying up. What to do about it? And you have like 10 remedies at least, like that applies to that situation. So that problem and that work will always remain, as such. And newer remedies will be invented to solve the same problems. There were originally Provincial and Presidency Insolvency Town Planning Act Part 3 of the IBC has not yet been notified, but eventually personal insolvencies will be created, jurisdiction is given to DRT. All that work will keep happening. And in district places, there are cooperative banks, like in Maharashtra, we call them the cooperative credit societies, Patpedis, and all that. So very similar in Gujarat, the structure, because the law was same until the 70s. So all that, litigation remains. Within the property, there is agricultural property has its own set of issues, which are mutation entries done by the revenue authorities under the, what is Maharashtra Land Revenue Code or the Gujarat Land Revenue Code. Appeals are given to the subdivisional officer, then to the collector, and later on to through the writ petitions. There are Mamlatdar Courts Act, which is a very old act of 19th century, but it has its own limited court mechanisms and all that. So lots of work in that sense. The broad idea I'm trying to convey is that if you start off in district place, you're not at a great disadvantage, but you have a range of work. So he's like a MBBS doctor in a small place who has to treat everything from cancer to bruises or cuts and wounds. But there is a range of work. Some people like range of work because they get bored with only one type of work. Some people want to be specialist in one kind of work. So different flavors for different people. Anyway, coming to High Court's arbitration and trial practice actually is limited to just 5 High Courts, because only 5 High Courts in India have original side jurisdiction. All other High Courts in India have only appellate jurisdiction. So there, if you practice anything civil, it's essentially or writ practice, that's all under the appellate essentially jurisdiction. Not under the or writ jurisdiction, which stands on its own, but you are not doing trials there. No evidence is being recorded in those. You can record technical evidence in first appeal, but that's a different, like a theoretical, like an issue. What are those, the 4 metro cities, Calcutta, Bombay, Delhi, Madras, have original jurisdictions, the High Courts here, and Himachal Pradesh. So these are 5 High Courts with original jurisdictions where you can file a suit. They have ordinary original jurisdiction and extraordinary original jurisdiction, coming from letters patent or a statute and all this, this thing. So there is a lot of trial practice, and because there is a lot of economy and commerce in these centers, being large metropolitan cities, there is a lot of commercial litigation in these places. And because of that reason, commercial litigation exists so much, arbitration and commercial arbitration has also picked up in the big way, because it's an offshoot of the overall commercial litigation being filed in these courts. And they have city civil courts like in Ahmedabad and, or district courts in other places and all that. All that stuff is there, in the metropolitan cities also, as a court lower to the, in pecuniary jurisdiction, particular to the High Court's original side jurisdiction. Somewhere it's 1 crore, somewhere it's 2 crore for those little lower level of courts, in pecuniary. So there is a lot of commercial litigation, commercial arbitration happening in the High Courts where these 5 High Courts are located. and also in other places where like which are economically growing or where there are benches. So Lucknow, Indore, or any Jabalpur, I mean, wherever the benches are, you know, Jodhpur, etc. And there is a lot of government related like litigation, commercial arbitration happening in this center. They may not have original jurisdiction, but because government issues a lot of contracts for procuring everything. I mean, you know, chairs in a hospital, beds in a hospital, everything is a tender. I mean, and so all that can be litigated via the writ petition if there are malafides or irregularities in the process. But otherwise, the writ court sends you to back to arbitration. That you have an arbitration clause, you figure out, you know, your whatever damages you want in the arbitration. So there is work there also. So not to say that there is not of much of work, but yes, it's a fact that these 4 high courts in particular of the large metropolitan cities, they have a large concentration of commercial work because a lot of contracts are done there, a lot of banks are here, a lot of financing is happening here. So that's how it is. So choosing to do trial practice in this trial practice or arbitration practice exclusively, or a mix of both these practices in these 2 locations, is not a bad choice if you can do it. The entry points to start with, essentially, you join a senior lawyer or you join, you know, like a law firm or a group of lawyers to like do with. Because one thing I would suggest to and tell everybody is you'll need a network which can refer clients to you. And unfortunately, neither the bar or our you know, like anywhere across, there is just no idea given to anybody just starting off or early on that you'll need a network who knows you as a person, that you exist and you're a lawyer. It takes 1 year even for your own friends and family to know that you have started practice. By that, if you set up a new practice, I mean. And then them to remember when they have a problem, oh, like so-and-so is a lawyer in our family or extended friend circle. Let's talk to him about the problem and see if he can represent us in court, or he can just listen to us and give some advice. So it needs that. So I would suggest anybody in law college to start building a network. Now, how do you like do that networking? The professional way is to essentially, you know, just know a lot of people. Just know socially, friend circle, through your hobbies, through your interests, through relatives, through friends, any medium you take up. So one is, you know, like you become very famous or good at something and people discover you as a person who can solve their problems, or you know a lot of people and within that, you know, a subset comes to you to ask a solution for their problems. I mean, either way it works. I mean, I'm not saying one should go out and make a lot of friends and all that, but a lot of people will need to know you one way or other. Either they come by you reaching out to them or they reaching out to you. So start knowing a lot of people, and you may join a law firm, you may become a partner later on within 8 to 10 years. You'll eventually understand that having your own standing within the society as a lawyer of some kind, of some specialty, is a necessity. There is no escape. No partner in the firm also can say that I am okay with nobody knowing me, and only because I work in a firm, I should automatically get work. It doesn't happen that way. I mean, you have to be, that's why you see law firms constantly writing articles, law firm lawyers, partners constantly, you know, reaching out to people, etc. Because that's just a necessity. Unless people know you, how would they know that you are good at something or bad at something? We are not allowed to advertise, that's a fact, I mean. But just the fact that people should know you is a requirement, and know your specialty over time, that you are really good at it. And it's for them to conclude whether you are good at bad at it. It doesn't matter if you say that I am good at this or I am good at that. People have their own mechanism to filter out. Just like when we want to consult a doctor, we ask our 10 friends, koi doctor hai kya acha? Who is a good doctor in this area? Have you had good experience with them? Are they charging reasonably? What's their integrity, honesty, reputation? It's the same way clients, you know, like check a lawyer's background before coming to them for some work to be done. Have you dealt with this problem before? What's your experience in this area and all that? So people will do this due diligence for you as a lawyer also. So it's necessary to start off early and have a network that can eventually refer work to you as such. Quickly, I think I have 5-6 minutes left. I mean, if we consider an hour of time, trials and arbitrations are very similar. So I have a lot of traffic on my communication, which says I want to be an arbitration lawyer. I don't want to go to courts. It's all right to say that and all right to expect that. And let's hope you get enough work, or if you are in a law firm which is a lot of arbitration work, you don't need to do trial practice. That's a choice. No problem with that. But to say that I don't want to even know what trial practice is about or what a trial is about, I think that's too much to presume that there exists like a system whereby you can learn all the commercial litigation principles only via arbitration. I think trials are a good way to learn it also, or just knowing about trials or commercial litigation in general. So don't shun litigation completely. It's okay to spend, there are talks by very senior lawyers on YouTube. I mean, Fali Nariman, Arvind Datar, who all have one common advice to say that spend a year at least in trial courts if you are going to be a dispute lawyer. Learn how to deal with facts, because appellate courts have pre-digested facts. They have very condensed facts. But from a vast universe of fact, to pick out relevant facts or fact in issue, it's not an automatic skill. Nobody is born with it. You have to deal with facts to learn to filter them out and present relevant facts as your pleadings and then in arguments and all that. I mean, so take some time. If life affords you a year to spend in trial courts, it's all right to do it. I mean, you won't lose out much over a 40-year of career, 40-50 years of your career. So that's all I have to say. And only one thing I would say is if you were to prepare for it while in your college, is know the Civil Procedure Code 1908 and the Evidence Act 1872 as much as anything else in life. It should really be part of your bone and marrow. I mean, really part of your nervous system, the blood circulation system, your basically whole your mind, body, and existence. I mean, that level of preparation or expertise, if you can develop in these two subjects, you will hit a jackpot early in career. People say it takes 5-6 years to develop as a trial lawyer or develop some practice or expertise or learn trial practice. I think it should not take you more than 1 or 2 years based on the opportunities you get if you have a really solid background in Civil Procedure Code and the Evidence Act. These are two amazing subjects to learn, and also you'll automatically learn, what is needed as input to the arbitration practice. I mean, if you know these two things very well, because arbitration practice, like other tribunal practice, essentially is broadly dilution of what is the trial court practice mechanism, because you have more trust in the system and parties and a private judge. So learn CPC and evidence very well. So that's all I had to say. I think I am within time of 4 to 5, 1 hour.
Thank you, sir. Sir, we have some questions from the participants. The first
Yes.
question is, what remedies are available? What remedies are available where a party starts court proceedings in breach of an arbitration agreement or initiates arbitration in breach of a valid jurisdiction clause?
Yes, so Section 11 is there in the Arbitration Act that if one party proposes arbitration and other party does not agree to it or has sent an arbitration notice and has not responded to it at all, Section 11 remedies exist to move a high court. There is an amendment yet not notified. Eventually, these appointment powers are going to go to approved recognized arbitral institutions, but not yet happened. You still have to go to high courts, I mean, and you can get an arbitrator appointed. If the other side, despite the presence of an arbitration clause, files a civil suit, then you have a remedy under Section 8, essentially under the Arbitration and Conciliation Act to tell the court or apply to the court that please send this matter to the arbitration because there is an arbitration clause in it. And all those judgments with Rolia and all that, I mean, which came out last year, are essentially about that, how those Section 8 proceedings, like the court really doesn't have to get into details of the dispute, simply refer the matter to the arbitral tribunal. I mean, as such, if parties can agree, then to the agreed tribunal, or again go to the High Court and appoint somebody as arbitrator.
So we have another question, that is, do you think we need new reforms in order to improve arbitration mechanism in India, among of which focus should be made on to encourage the use of arbitration for matters related to international commercial arbitration?
No, I think we have enough laws and already enough these things. So, I mean, I'll give you an example. I was in my third year of law and Nani Palkiwala was giving a public talk at a British Council library, and liberalization of the economy had just happened. And there were like hardly 20 people in the audience. I mean, because some rains or something had come, and that's why a lot of people could not attend. So I was sitting there and I had an opportunity to ask questions. I mean, after he gave his prepared talk. So I said, what reforms should be carried out? I asked a question to him that what reforms should be carried out, or what amendments or new laws we need, to, deal with the liberalized economy. And this is somebody who, was very prominent in advocate of liberalization of the economy, has written his We the People and We the Nation books, where he was a big advocate of and had spoken a lot about liberalization of economy. He just told me that we don't need more laws and more amendments. I mean, if whatever is there is used is enough. I mean, so just this is the same answer I'll give you. See, apart from the core law, to give you an example, see, Pakistan still has the old Arbitration Act that we had, which is the Arbitration Act 1940, which the Britishers gave us. They don't have a UN Citral model law-based Arbitration Act, I mean, which we have in 96. But apart from those big tectonic changes that we have needed, I mean, to move to a new regime completely, like the insolvency and bankruptcy code from the earlier regime, I think more or less legislations just need to be tweaked. I mean, they don't need to be like all that reform. It's good to write articles about it. In fact, I told somebody that there should be ban on writing articles about amendments to the Arbitration and Conciliation Act, because we have 2015 amendments, 19 amendments, and government keeps on amending it and there is no stability. In fact, there is a common joke across the commercial litigation field, that it's an occupational hazard to buy a book on insolvency and bankruptcy, the Bare Act of Insolvency Bankruptcy Code. Because by the time you buy it, and you come back to your office, the government has already amended the IBC. So your Bare Act becomes, like within the few hours, you don't know, it's a joke, I mean. But too frequent amendments to too many things actually, makes the system very hard, I mean, to run. Yeah, so somebody has asked, does the applicable law recognize the separability of the arbitration agreement? If you want to follow, NN Global is where it's referred to a larger bench, and that's a stamp duty related issue, but separability is well recognized in Indian law, that arbitration agreement and the main agreement are separate, that legal fiction is well recognized. Lok adalats to the arbitration as well. I mean, you don't want mass arbitrations, I mean, but there is a case for, class actions converted into arbitrations. There's a lot of debate in US law about it, that should this happen, shouldn't this not happen. But there are no facts here available, social demand here to, either implement it or not implement class action via arbitrations. Some suggestions for good books for international arbitration. Redfern and Hunter is there. There is a smaller book by Margaret, is her name. I'll give you the name, as such, before I finish. But that's a good book to have an overview about international arbitration. But a lot of these arbitration centers, if you go to their website, they have good introductory material. If you go to SIAC's website, which is Singapore International Arbitration Center's website, they have a set of videos which actually show you how an arbitration, international commercial arbitration plays out.
Okay.
And with actors and real lawyers and all that, I mean, and how evidence is taken and how arguments are done. It's a set of, I think, 9 or 10 videos. So you can watch that, and I think that's a good enough introduction to everything. I mean, and the mother body of, you know, all this is the UNCITRAL website. So UNCITRAL website has not only the text, I mean, of the model law and the New York Convention and all that, I mean, is there, but it also has, I mean, preparatory, it also has commentaries, I mean, available on all these materials, I mean. So lots of free, ample, easily available material is there, I mean. So don't spend money on books if you just want a basic introduction, I mean, to these things. I mean, enough material is available. Then go out and choose either. So Redfern and Hunter has a good book. Gary Vaughan has a good book on international commercial arbitration. But these are very expensive books. So, but Redfern and Hunter is unique. I mean, if you look at his interviews, Professor Martin Hunter's website, and he passed away last year, he had actually insisted to his publishers that there will be a low-cost student edition of his book, that you will not just publish the practitioner's edition. And he's insisted, or at least hoped, I mean, there is an interview with his current editors of his book, that he wants it to be just one volume. He doesn't want it to be a multi-volume commentary. So it's there, and one of the best books and one of the best teachers of it is there. But they do a global survey and all that. I mean, so the broad material is there. Reading a book won't be able to get you to become an international arbitration practitioner. I mean, there are CIAP courses. CIAP website has a lot of materials. Lots of free material is available. That's all. I would suggest you start from there. And commercial dispute to two different countries dealt with in arbitration. That's what international commercial arbitration is there, if a clause exists, I mean, or else, you know, like you can do litigation in one country, have a decree, and through committee of courts and RCPC also has provision, try and execute the decree in a foreign jurisdiction. Very hard to do it actually, but it's possible, I mean, to do it. That's all I have to say.
Yeah.
Thank you.
I hope, is there any other questions, Tarush?
No, ma'am. Sir has answered all the questions. I would like to hand it over to Omami.
Okay. Before that, I just want to convey my regards, gratitude. Sir, Hasit sir, really, in your busy schedule, I can understand you take out your time. And since from the long time, I was keep on requesting to have a session, to have an interaction, because your rich experience, okay, your journey in this legal profession, definitely what I noticed is that our student got benefited out of the way you just put forth the things. Because what happened, Hasit sir, presently, the students are more into what I'm noticing, the present generation student, they just want to step into the corporate world and sitting at one place, and they just want to put forth their career practice. Okay. But people, there is a lot of scope if they go to the litigation part. Right now, you rightly mentioned the trial practice and put forth thing, or a combination of the trial and arbitration. And it is going to be a great career opportunities. But now present generation students are not into. Just they want to join to the corporate, they need a good package, and they want to sit at one place. And that is how the practice is going on. Okay, I think you made very clear for the student the what and all the career opportunities that are there, taking up the civil practice, taking up as a part of the arbitration. Thank you so much for your insightful session. On behalf of all the students and my faculty, really, I extend my thanks. Okay.
No, thank you, ma'am. Thank you for the opportunity. And I would just suggest that you are a lawyer, right? Or you'll soon be a lawyer. I mean, you have magnificent possibilities to serve your family, your community, and the country, I mean, as such. And also this profession, we are a licensed profession, right? I mean, we are just like doctors, I mean. So not everybody gets to, you know, like practice law. And unlike the doctors, we have only one kind of bar council. There's no Ayurveda, there is no homeopathy, nothing here. I mean, only one kind of lawyers. I mean, so, I mean, Hope you enjoy your journey. I mean, and it is interesting. That's all I can say.
Yes, yes, yes. Even we too enjoyed, and we too gained a lot of information.
And
from your-
academics is something, if that is your calling, I would suggest, to also explore it, because the
Yes.
standards, I mean, and the amount of work that can be done in legal academics in India, we still have made a start. There is a long way to go.
Absolutely.
So a lot of writing needs to be done, a lot of research needs to be done. So if that is your calling, please follow it. I mean, and lots of, to tell you just one example, lots of top arbitration practitioners are both. They are professors of law, like Professor Mistelis, Professor Krina Baltag, all are professors and arbitrators at the same time. So, I mean, there is nothing to say you can't do both, I mean, except there are some regulatory issues, that's a different thing, but it's possible to do both internationally and this thing. So don't underestimate academics as a career also.
Absolutely. Rightly mentioned. Okay. Tarush? Yes. Tarush, is he there?
Om, please take over.
Yes, ma'am. Om will start the vote of thanks, ma'am.
Thank you so much, ma'am, for your kind and motivational words. Feeling gratitude and not expressing it is like wrapping a gift and not giving it. I extend my gratitude to honorable guest and express my special thanks to all the participants of the webinar for their presence and contribution to make this webinar a great success. I extend my gratitude to our honorable speaker, Advocate Hasit, Seth, to take out time from his busy schedule and to grace the event. Thank you so much, sir, for inspiring us and providing knowledge through this webinar and perfect demonstration about how alternative dispute resolution mechanism provides scientifically developed techniques to Indian judiciary, which helps in reducing the burden on the courts and encouraging us with your knowledge on other aspects of the same topic. This session was indeed very informative and would help law students in their future. Thank you so much, sir. A special thanks to Dr. Sujata Patil, Principal of School of Business and Law, Navarchna University, for providing immense support to make the webinar successful. I must thank the organizing team for the making of the webinar successful. Last but not the least, my deep sense of thanks and appreciation goes to all the participants who were attending this webinar with great enthusiasm, and they made today's event a great success. In the end, thank you all for being with us. Have a wonderful day ahead.
Thank you everybody. Thank you, Dr. Patil. My best wishes.
Thank you, sir. We'll continue our association. Thank you so much.